Welcome to episode 113. I'm Stuart McCullough, I'm the CEO of VHIA, and it's time for this week's Industrial Roundup. This week's Industrial Roundup, a big thanks to our community health members for their attendance at last week's HRIR Managers Meeting. With respect to health services, this week we have a meeting of the Biomedical Engineers Reference Group on Monday. On Wednesday, we're attending a meeting of the Occupational Health and Safety Advisory Committee. That's a committee that's conducted by WorkSafe at WorkSafe in Geelong and features a range of different unions and different employer representatives across a range of different industries. On Thursday, we'll be filming on site with a member in terms of their CME for medical specialists arrangements, and the IR report for Metro members will be issued this week. By now, members will have received a copy of the VHIA bargaining framework. A big thanks to those members who did provide feedback for that document. Just to remind members that the purpose of that document is to set out how bargaining will function. And includes crucial information such as how members can participate in bargaining, how information during the bargaining process will be distributed, and the member approval process for agreements in principle. And finally, just a reminder to members to join the VHIA Yammer network. The VHIA Yammer network replaces the previous VHIA community app, and it will be the means by which we provide members with meeting-by-meeting updates during the bargaining process. If you've not done so already, I'd strongly to encourage you to accept the invite and ensure that you're familiar with that technology before bargaining commences. As always, all of our activities are summarised through the VHIA Yammer network. And now it's time for the weekly update.
Good afternoon, everyone. My name is Jim Babalis, Workplace Relations Legal Officer here at the VHIA. And today here I have with me Lexie Roso, our Workplace Relations Consultant. Hi, Lexie.
Hi, Jim. Thank you for having me.
Now, Lexie, as we quite often do, we have, with these podcasts, we have a clue running. So I'm actually going to ask you to introduce the clue and try to guess what we're going to be talking about today.
Okay. So it's a book. The Dirt, Motley Crue.
It is. It is.
It's like a whiskey bottle.
It's a whiskey bottle. So any hint what it might be?
To be honest, not really, Jim.
Okay.
It doesn't give me a lot.
Doesn't give you a lot. So The Dirt, it's essentially the autobiography of Motley Crue, which has also been turned into a Netflix movie. And if you were to watch the movie and read the book, there are some serious occupational health and safety issues there involving all the four members of the band. So the topic for today is OHS Duties.
That makes sense now that you've explained it.
So happy reading whenever you want.
Thank you. So Jim, OHS is pretty broad. I guess, where do we even start?
Great question, Lexie. Well, unlike the Fair Work Act, we don't really have a single act which governs OHS. Instead, what we really have is something similar to WorkCover, which is a state-by-state hybrid approach, with one big exception though, and that is that the OHS Acts of all states and territories except Western Australia and Victoria are now modelled in the same fashion, the model laws as we call them. But having said it, the themes and the keys and the elements of the acts, as we call them, are somewhat analogous anyway. So there is some broad-based principles that just overlap.
And I guess many of the questions that we get here at VHIA are the bread and butter of OHS, such as hazards or warning signs. But I think it's safe to assume that's not all-encompassing.
Absolutely, Lexie. I mean, OHS, listen, if we could be quite honest about it, intersects in every facet of employment. For instance, when you're considering, just to give you one great example, issues around serious and willful misconduct in disciplinary matters, which we tend to find not just in the Fair Work regulations, but also in our EBAs as well. It's one of the main categories around it specifically is around acts or omissions that lead to risk of health and safety. And this is just a clear OHS issue, and it's something that essentially translate across the Act as well. The same can also be said for fitness for work considerations, which are found in almost all EBAs as well as in work cover matters and in the various work cover acts. It's safe to say that these are issues that are really born out of OH&S considerations.
And anecdotally, we hear sometimes about complaints being made about potential OH&S issues, and these obviously cause significant concern for some of our members. Can you elaborate as to the overarching considerations?
Great point there. I mean, OH&S is probably the most serious importance, and it really just shouldn't be just a throwaway line in any scenario. I guess the overarching considerations must relate to valid issues and circumstances, and most importantly, if I can indulge you, they must really relate to compliance issues specific to the actual duties that the Act or the Acts actually have.
And indulge me, what are the duties?
They're very broad. We can almost write books about it, but essentially in the Act itself, and essentially it's from sections 20 right through to section 39 of the OH&S Act in Victoria, you will find the various duties. I can read some of them just to give you an indication. They are quite broad. For instance, you have the concept of ensuring health and safety, the duty of employers to employees, the duty of employers to monitor health and conditions, the duties of employers to other persons. That runs through the main ones, and then you have duties to other persons, which are, for instance, the real hazard type situations that come up, the duties of persons to manage or control workplaces, the duties of designers of buildings or structures, and they go on and on and on. And then essentially we have other duties which are found almost at the end of what we call the duties provisions, and they relate essentially to incident scenarios such as the duty to notify of incidents and the duties to preserve and maintain the incident sites themselves. So they're pretty broad-based, about 20 of them. They cross essentially almost all industry groups.
You just answered my next question. So I guess it is a very extensive list of duties, as you mentioned, and it is designed to cover all
absolutely,
industry groups.
Yeah, no, that's absolutely correct there.
Then could you pinpoint, I guess, the duties which are most prevalent to our members in the health industry?
Listen, essentially, I think it's the main duties provisions, which I think have always caused OH&S delegates and lawyers the most concerns. And they're found at section 20 right through to 23 of the Act. And they essentially are the ones, if I could just retouch on again, are the concept of ensuring health and safety, the duty of employers to employees, the duties of employers to monitor health and conditions, as well as the duty of employers to other persons. They're the main ones. The other one that I'll probably want to throw in there as well is probably the one at section 25, and that's the duty of employees as well. Those 4 plus 1, I guess, tend to be the main ones.
And while they're the main duties that we have, and we have these duties, there are consequences for non-compliance, or?
Yeah, listen, I guess the consequences are pretty stringent, and to some extent they cross over with not just enforcement issues and orders that are analogous to other bodies such as ASIC or the ACCC, which tend to deal with corporate and commercial issues, but also various criminal powers as well, which tend to come through from, I guess, state criminal powers, even federal criminal powers. They're pretty extensive, the list, so I might just run through with them because there are a number of consequences. But essentially, what you tend to find is the powers of WorkSafe, particularly the inspectors and the prosecutors, can lead to very heavy fines and penalties. The main ones, I guess, Lexie, are as follows. Something we call provisional improvement notices, which is essentially an early intervention list. And that is where, or PIN as it's more affectionately called, is where the person who issues that believes that the OH&S Act is being breached, or the potential is to be breached, and is likely that the breach will be repeated and continued. And essentially it's a notification that is actually issued that requires the employer in these instances to rectify the problem and the cause of the actual problem. So essentially it's putting the employer on notice that you better do something to fix this risk. Then you also have the inspectors who can issue orders such as securing compliance, and that's where an inspector, usually from WorkSafe here in Victoria, ComCare in the federal body, enters and inspects the workplace. Permission is not necessarily essential, which is a bit of an anomaly, I guess, when you look at the criminal powers where you need warrants. But anyway, that's the reality of what we have, and they essentially just come on. The inspectors come onto the site. They issue directions or notices compliance with, essentially wanting compliance with the actual act. They can also investigate the potential breaches and can even issue prosecution notices. So there's things that can occur with the inspectors. One thing that is categorical, though, the inspector's powers are not those of, I guess, an inquisitor. They're not there to essentially act as if there's some all-encompassing power. It's an offence for them to essentially just hinder, obstruct, cause a ruckus in the workplace. They're not there to do that. They're essentially there to be somewhat of an investigator. And dare I say, there are also consequences of an inspector pretending to be someone that they're not. They can cause some real issues. Some of the other aspects of compliance provisions are what we call the enforcement measures, and that's essentially the part of the Act which actually gets a bit meaty and juicy. And some of the enforcement measures that the Act and WorkSafe allows are compliance audits and inspections, and that's where WorkSafe can actually undertake their own inspection or investigation, and can actually issue warnings letters where the Act has actually been breached. They can also, the enforcement measures can also issue inspection notices, etc., prohibition and non-disturbance notices as well. They're usually, I guess, the more low-level enforcement measures that might actually exist, and it's really just designed to put someone on notice to essentially start complying. On-the-spot fines, though, is probably one of the more common enforcement mechanisms that we tend to see. And they can be fines, significant monetary fines. Most of them tend to be a little bit more of the low level range, usually under about $10,000, and usually covers, I guess, the minor offences. And I guess they're the ones where there might not be adequate hazard notices in the workplace, issues with machinery, etc., etc. Something that you tend to call, I guess, in private practice, your small business effect scenarios. And it's important to note that some of these can actually end up in prosecution in the courts, particularly the Magistrates' Court. One of the other ones that's actually very common, just to probably indulge you a little bit further, is something that we call enforceable undertakings. They're very common, I guess, in New South Wales, less so here in Victoria. The concept of enforceable undertakings is essentially a criminal regime. It's taken from what we would define as the diversion program that does exist in the Crimes Act. And I'm sure, listen, you may have done criminal law as a placement, I guess, at some point in time, and you might have seen that diversion programs are pretty common in the Magistrates' Court. Enforceable undertakings is very similar. Very common, I guess, like I said, in New South Wales, mainly in the building and construction sector, transport and logistics sector as well. And that's essentially where an employer pleads guilty to an offence, receives a pretty hefty monetary fine, as well as an undertaking to do community type work to improve their standing and issues that have led to the OHS breach. Dare I say, they're not reportable, okay? So they're just something that we need to be mindful of. Whether they're common in the health sector or the aged care sector is a little bit of a misnomer at this point in time, but I'm sure that we'll begin to see them a bit more. Prosecutions is where we tend to see some real oomph around enforcement measures. Obviously where enough admissible evidence does exist, and where the OHS laws and have been breached and there's a public interest to actually prosecute, WorkSafe will actually do just that. They've got a very very large team with a very long, I guess, portfolio to go out there and prosecute. Dare I say, if a prosecution notice hasn't been issued within about 6 months, the chance of it happening are pretty remote, if not impossible. But they are very, very common. 9 out of 10 tend to resolve with costs payable and essentially fines issued. Okay, usually fines can be up to about $50,000, and costs usually are on scale, usually around the $10,000 mark. So they're very common as well, and listen, in most cases they just do settle for various reasons. The fines are something that always do cause, I guess, employers' concerns, because the OHS Act does allow for fines. They can range, dare I say, to the significant for individuals such as directors or people who make delegated decisions, or even employees. They can range usually somewhere just shy of $300,000, and for corporations they tend to be in excess of about $3 million, but they're at the absolute maximum level. Unlikely that you tend to see those type of fines issued, but they are problematic. And it's also important to note that like the powers of ASIC, WorkSafe can actually also criminally prosecute someone with jail terms. Section 32 of the Act does allow it. Unlikely that would occur unless there's actually been a charge of, I guess, industrial manslaughter or the like, really. But the criminal powers to send individuals to prison are there, and it's just something that I guess employers need to be quite mindful of. So that's just something that, unfortunately, we just always have to have in the back of our mind. They tend to be the main enforcement measures. The other one, obviously, are the alternative penalty options. Just briefly, in addition to fines or imprisonment, courts can also impose, I guess, adverse publicity orders, health and safety undertakings, or orders to undertake improvement projects. They're just the broad discretionary powers that the courts actually have within their inherent regime. The Magistrates Court obviously has this, and every so often you'll probably just notice in the industrial division list that those orders have actually been issued. And usually they do address, I guess, public relations considerations would be the main areas that you tend to find.
Wow, it seems like serious compliance is necessary. Are there any final thoughts that you have for us today?
Yeah, I guess, listen, I tend to view things as, I guess, a bit of a trilogy sometimes. My recommendation, I guess the recommendation that we always have in these considerations is, aside from regular review, the three main points that all members need to take out of this are what I would call, in this instance, the 3 S's. It's quite important for our members to not just be safe, but be strategic and supportive in order to meet their requirements under the Act as well as their duties. I think if they do that, they've at least got a matrix to operate with to essentially meet compliance with the Act itself.
Seems fair enough.
Hope so. I guess that's all from me, unless there's any final questions, really.
No, I think that covers everything. But thank you very much for having me today.
No, my pleasure. Thank you.